Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We are located at 1563 Main Street in Peckville, and I am here with you every Sunday from 8 to 9 a.m. to provide landowners valuable information you need regarding the Marcellus Shale development and gas development here in the state of Pennsylvania. And of course, if you're looking for landowner information, this is the show for you. I represent landowners and only landowners, and my practice is pretty much dedicated to this natural gas development and has been now for a few years, dating back to my first starting in this in 2007. So we've been doing this radio show, I have, since August of 2010. And if you want to go back and check out any of the prior shows, you can go to the websites at pagasleaseattorney.com and pipelineattorney.com. What we do is we archive the radio shows, and this show that you're listening to here today, we will have this up tomorrow, and it'll be available all week on the main section of the website, and then we'll put it to the archive section so you can go back. We're closing in on 150 radio shows that are available on the website, so you can go back, check those out anytime. Again, that's pagasleaseattorney.com and pipelineattorney.com. Check out the show there. And reminder, what do? I represent landowners and only landowners in natural gas issues and such items as gas lease negotiations, and there's been some more of that. What we see is companies now, we're not in this free open leasing all across the state or in regions of the state that we used to be. But what we see now is we've seen some pockets where leases have expired, or where leases were never taken, or where people have entered into a lease and maybe some of these leases have expired for various reasons. Maybe they had a good PU clause and some of the land is coming out of that area. So we're seeing pockets of areas where we're getting calls from people saying, hey, I have a new lease offer. So we're doing a lot more of that. And another thing I've been doing a lot more of recently, I know there's more out there and there's more coming, and this is a very important document. A lot of people are receiving amendments and modification documents. And what those are documents when you have already signed a gas lease, for example, and a company comes back and says, hey, we need to amend or modify the terms of your original gas lease. And this can be done for a lot of different reasons and to a lot of different types of leases. And one that we see often, or one set of amendments and modifications that I often see, relate to some of these group leases, if you will, where many landowners got together and they had a very strong lease, and we see this often with the Friendsville lease, but there's many others as well, and it doesn't have to be a group lease. But what happens is the company's now looking to develop. They gave everybody all of these terms at the beginning when you entered into your your gas lease agreement. But now, as development is going, the company is looking at these leases and saying, you know what, there's items in here that we don't like, and we want to modify or amend these items with the landowner so we can go ahead and move forward. Now, I certainly have a belief that these companies knew in many, many cases at the time that they gave landowners certain terms that they were never going to develop under those terms. Unfortunately, I believe that to be the case, and I think as we look back on that it's pretty clear that has been the case, or was the case at the time as well. So what we see is one of the biggest areas of the amendment and modification that we see often, or I see, and I see that no matter which company, and that's the thing with what we do, we're not in a vacuum working with only one company. We're working with all companies across the state of Pennsylvania. So what we see is we see one of these leases, or we see lease terms, and for example, a very common lease term that companies do not like is a term that will provide the landowner with this guaranteed minimum well obligation by the company. And what do I mean by that? Well, the company in the lease agreement, in the gas lease, say they agree to drill 4 wells within a 10-year period. And that can be written a lot of different ways. And sometimes, once you drill 1, you have another 5 years to drill 3 more. But let's make this simple and say that your lease requires a company from the date that you sign the lease to drill 4 wells, a minimum of 4 horizontal or Marcellus wells within a 10-year period from the time you signed. So you enter into this lease. Well, now here comes the company knocking on your door saying, hey, we would like you to sign an amendment and modification to your original gas lease. Well, you're faced with the decision. What does this mean? Well, first thing you need to do is you need to understand what your original oil and gas lease states. What are those terms and what exactly is the company asking to modify? And with every agreement, if you listen to the show regularly, I say this leverage word all the time. You must understand your leverage. You must understand what you're being asked to do. You must understand what is the impact that this request is going to have on my original agreement. And what is my leverage? What is my ability to say no? What is my ability to negotiate this? Can I get more money? Can I get an increase in royalty percentage? If I do say no, what could be the negative effect of saying no? Well, should I just say yes? All of these are critical questions, and very often for a landowner who's not dealing with these issues all the time, you can make the wrong decisions, because sometimes it is that you're going to be in a position where clearly your best option is going to be to go ahead and sign that modification. However, in other cases, clearly your best option may be to try to negotiate this agreement or to simply say no. If you have a well site on your property and there are already 2 wells that are on that well site and drilling out in a part of your unit, and a company says, hey, landowner, we'd like to amend or modify your lease, and so now we don't have to drill any more wells, we can just sit pat with these 2 wells. Well, as a landowner, you have a lot of leverage there. Well, why would I go ahead and agree to amend or modify this lease when I'm guaranteed 2 more wells, which the time value of that money and that production is going to benefit me? So I'm guaranteed that. Why would I waive that? Well, maybe I want to waive it, but if I'm going to waive it, it's because there's going to be some sort of motivation or compensation. This quid pro quo. I'm going to give you something. You're going to give me something. So maybe your original lease was at 15% royalty, and maybe the company will increase that royalty percentage to 16, 17, 18, whatever that case may be. Now, again, that's a rare circumstance, but I'll tell you what, you really don't want to just go and sign that document in that case, because there's probably something that can be done. Or you can simply say no, and the company's going to be forced to drill 2 more wells or relinquish your lease. And they're certainly not going to want to do that if they have 2 wells and a pad constructed on your property. In this extreme example, it's just something they're not going to want to do. So you really want to make sure that you understand what your leverage is. I am Attorney Doug Clark, and you're listening to All Things Marcellus, and I want to keep on this topic for a little bit longer and say, this is an extreme example to make it easy to understand, but there are a lot of nuances to these amendments and modification agreements. There's a lot of them, and sometimes you'll get an amendment and modification from the gas company, but also a consent to assign your lease to another company. What do I mean by that? Well, your company may come to you and say, hey, we would like you to agree to allow us to assign your oil and gas lease to a third company, a company that you didn't enter into a lease with, just a different company. So your company, we'll use an example, a realistic example that sometimes happens, and it's happened recently for me, for a client. So say Talisman has your lease, and your lease is one of these Friendsville leases. And I hate to pigeon it into or place one type of example here, because this can happen in many ways. So please understand that. But for illustration, we're just going to say Talisman lease with you. Make it simple. Say it's a Friendsville lease. Please understand that you don't have to have the Friendsville lease for this situation to come up. So Talisman approaches you, says, hey, we'd like to amend and modify your lease. You want to look at your lease, and you want to look at that amendment and modification and what in the world is in there. They can be super complicated. They are sometimes like putting together very complicated puzzles. What do I mean by that? Well, what can happen is you can look at this and it'll say, you may have a 10-page lease, a 15-page lease, and it may say, paragraph 6 on page 3, third sentence changes from blank, and it'll state that sentence, and then it'll say, here's the new sentence. And you can imagine if you have 10 of those, 15 of those in this amendment modification, that can get very confusing and very complicated just to follow those things, yet alone to understand what exactly you're being asked to do. So first you have to put the pieces together so you understand it. Then once you understand the actual words and the language, well, what are the implications? What's going to happen as a result of you agreeing to this? I mean, why are they asking this? What is going to happen? So In my opinion, these are very important. Well, they are. I don't care whose opinion. They're extremely important documents that you must understand. And in most cases, and with every case like this, you really need to get some assistance from somebody who knows what they're doing, has the experience, and can assist you. I don't want to make this a commercial for me. I want to say whoever it is, whether it's, I always say I can't represent everybody. If you have this issue, certainly this is something we deal with all the time. But whether it's me or somebody else, get some assistance on this issue. It may be simple. It may be, hey, here's what the situation is. Here's the evaluation process. Unfortunately, you don't have any leverage and you should probably do this, and here's why you should do it. Or let's take a few steps back. You have a situation here where you have some leverage and you may want to say no, or you may want to try to negotiate, which could result in some cases to substantial compensation. That's not often, but it certainly has occurred. So you need to look out for those things. Again, I am Attorney Doug Clark. This is All Things Marcellus, and we're talking about amendment and modifications and very, very important documents. And just to finish this part up, I'm going to finish out this segment with this topic, and we're going to get into some other items as well, obviously, here for the next part of the hour. But to finish this up, I talked about consent, amendment, and modifications. What do I mean? Well, you have a modification and amendment where the company is asking you to agree to amend and modify your lease. First step is going to be backwards, saying, whoa, why would I do this? I spent a lot of time and effort negotiating my first lease. Maybe I've even paid an attorney. I was part of a group, whatever the case may be. I'm not inclined. I don't want to change, amend, and modify my lease. The company, let me say this. When a company comes to you to amend and modify your lease, why are they doing that? Because it's going to benefit you or because it's going to benefit them? Now, in some cases, there may be a benefit to both. However, typically, that company is coming because they're going to receive the greater part of that benefit. However, you may not have any negotiation power to say no to this, but you need to understand that. You must understand what you're being asked to do, why you're being asked to do this, and what type of implication or what type of effect is this request, and if you sign, what's it going to do in the future? You must understand these things. It is critical. And you need to understand, if you don't have leverage, you don't want to spin your wheels fighting with the company. And if you have an attorney, you should not be paying your attorney to spin wheels and take your time and take your money for something that's never going to happen. That you're not going to get these maybe outlandish or far-reaching requests. You need to understand, are my requests reasonable? What do we see happening here? So that's the next part of it. So to finish this, what I see sometimes is, and this is something you need to understand. Say my example, Talisman Lease, Friendsville Lease. Company guy comes out there, says, hey, landowner, we'd like you to sign this amendment and modification, which is going to change the terms of your lease. And also as part of this document, you're going to see that we're requesting your permission to assign or transfer this lease to another company. Well, that may be a good situation because that other company is looking, it's not typically going to be just your lease, sometimes it is, but that other company is going to be planning on developing this property if they receive it in most cases. Now again, you have to do some work. Your attorney has to do some work. You need to understand, why is it going to be assigned? What is the plan of the new company? Get some information. Understand, you don't want to assign or change or modify your lease if it's going to result in that lease not being developed. So you really need to do some digging into that. Okay, I jumped off here talking lease modifications because it's something that I've been dealing with a lot lately. I'm going to get back. We had our mediation this past week down in Philadelphia regarding the royalty issue. I'm going to touch on that briefly. We've talked a lot. I have talked a lot the last several weeks about the royalty issue. So I'm going to touch on that. I want to get into some pipelines. I want to give everybody a break. We switched to the new station, and I've been doing nothing but royalty talk. So I'm going to give everyone a little break. I'm going to talk about it some, but we're going to get back. We're going to talk about some other items as well. We're going to talk about some pipelines today and some really exciting things that have been going on there. You are listening to All Things Marcellus with me, Attorney Doug Clark. We'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Want to remind everybody, we recently switched stations here. So we have access now. So if you're listening, we're in a whole different area than I used to be as far as in the northeastern part of the state. And when I say a whole different, there's many overlapping areas, but we're also reaching Montrose, Wyalusing, Athens, Sayre, getting out to in Tunkhannock, getting out to a lot of different areas to make sure that landowners have access to information you need. I've been doing the show since August of 2010. So on the websites, you can go check out at pagasleaseattorney.com. Really encourage you, go check out the website if you have internet access. There's a lot of great information, whether you're looking for representation or looking for simply information. Go check out pagasleaseattorney.com. We have the radio shows. One section of the website is dedicated solely to the prior radio shows. So if you miss any of today's show or any of the shows since we switched here in the beginning of April to the new stations, you can go check those out. I'm going to talk a little bit about the royalty issue in this segment. I've done many hours of shows on the royalty issues and deductions and post-production costs. Give people a little bit of break this week, but I'll be talking about it, I'm sure, in weeks to come. But I don't want to make the show just about that issue. So you can go back. You can check out pagasleaseattorney.com. I'm going to talk about some pipelines today. Have a website dedicated solely to pipeline issues. That's pipelineattorney.com. Whether you're looking for representation or just information, go check these out. What we do at the website is, again, we put the radio show up there, and what I used to do, it used to be a little delay before the time or from the time that I recorded the show until the following time when it airs or it's available on the website. So what we do now is you can listen every Sunday from 8 to 9 a.m., but starting tomorrow when we come in, we'll get the show up and available on the website, so you don't have to sit around and listen to or make sure that you're tuned in every morning from 8 to 9 as long as you have that internet access. And so a reminder, who am I? Doug Clark Law Firm, dedicated to representing land owners and only land owners. Done pipeline agreements with over 40 different companies all across the state of Pennsylvania. Gas leases, hundreds of gas leases we've done, involved in the royalty challenge against Chesapeake and other companies. So remember that too, and other companies across the state. We're fighting for royalty issues and are deductions appropriate? What's going on? Is the company violating the terms of your lease? So do a lot of gas lease negotiations, amendments and modifications we talked about, royalty deduction issues, unitization issues, doing a lot more and transitioning and doing more estate planning and succession planning for our clients. Is a trust right for you? Do you have your will in place? Do you need to create some sort of entity to hold your gas rights? What is right for you? And one of the things where what I'm take a lot of pride in, what's really important to me is that whatever we do and whatever I do is based on this individual in front of me, or who I'm working with, who is my client, who has hired me to work for them. We want to make sure that with the estate planning, that we have the plan that works for you, not your neighbor, or not the guy that has 100 acres if you have 10, or if you have 100. We don't want you to have the 10-acre plan. And everybody, we sit down with people. I've yet to find anyone who's come into the office that's in the identical situation as another person that's came into the office. So individual representation, individual assistance is critical in every single case. And of course, estate planning, it's even more pronounced because everybody's in a different circumstance. Everybody comes from a different set of situations where maybe you have a lot of children, you have one child, they're all over the country. Maybe you already had some wealth build up before this. Maybe you're getting great, very large royalty checks, or maybe you're getting very small royalty checks. Do you have the plan? Is the plan right for you and your circumstance? So that's very important. And remember, like I say, whether I'm assisting you or somebody else, these are things that get you thinking. You want to make sure that you have an estate plan that's right for you and your individual circumstances and your family. You don't need the Cadillac, Jaguar, Mercedes plan, maybe, because it's not the right plan for you. But maybe you are in a situation where you're getting a lot of royalties. And with your family situation and what's going on, maybe you need a more complicated plan. But get the plan that's right for you. I hate when I see it when I have clients come in for other matters, leases, pipelines, royalty issues, and they ask me to look at this, and I look at this and I think, wow, why did this occur this way? And people told them certain things, and they went ahead and did it, and they really didn't have a plan that was right for them and their circumstances. So no matter where you're doing this, make sure that you're getting individualized attention. It's just absolutely critical. Again, I am Doug Clark of the Clark Law Firm, and you're listening to All Things Marcellus. And I want to talk, we taught the first section, so if you missed it, we taught the first section about amendments and modifications of oil and gas leases. And I get these clients and these calls all the time, hey, the company asked me to amend or modify my existing oil and gas lease. You really need to understand, I'm going to leave it here, but saying you must understand your original oil and gas lease. You must understand exactly what is being asked, because these can be very complicated. Just to read them sometimes is extremely difficult the way they're worded when they're taking out words in a 20-page or 10-page or even 5-page document and adding in a single word here or there. Very, very critical that you understand those changes, but then also what is the impact of those changes and what are you being asked to do? If you sign this, what can you expect moving forward? I want to stress, as I always do, it is always an individual situation. So when I talk here, I can't say, and I'm not saying, hey, you should do this, you shouldn't do this. There's some things where I say, well, you should always go speak with a lawyer, or you should also get some more information if you're asked to do something. That's one thing. But as far as specific recommendations, that's not what we're doing here. We want to make sure that you're thinking about things, that you're considering these things, and then that you're moving forward with this information. And hopefully you're going to get some help somewhere to make sure that you're just not relying on the landman. Because if you haven't heard those shows, you can go back. The landman works for the company, not the landowner. The landman works for the company and not the landowner. I don't get very many people coming in and saying, boy, that landman was great, and he gave me all the terms that I wanted, and he helped me out so much. I get a lot of, hey, I was deceived or misled. Those type of things occurred. And if they gave you all the terms that you wanted, maybe you should have wanted some more, because there was probably some more available that you didn't get. So you need to make sure that with every single agreement, no matter what that agreement is, that you understand your position, your leverage, your options, and that you're maximizing your position. You must maximize your position, whether it's in increased terms, property protections, items or terms that are going to help to aid future development for your property, or is it simply compensation? Is there more money available, but you're not asking for it, or you're not asking in the right way, or you're not understanding what your leverage is? You need to maximize each and every single agreement. And so again, you want to get some information, go check out pagasleaseattorney.com, pipelineattorney.com. You can always call the office if you have any questions, 570-307-0702. That's 570-307-0702. Okay. I want to talk like I said, I've talked a lot in the last several weeks and over the last, year probably plus, been talking a lot about the royalty issue. And just to give everyone a quick update, we did have our mediation session this past week down in Philadelphia, and unfortunately we didn't get very far, and certainly there was no proposal that we were comfortable taking back and recommending to our clients. And just some background of that, we represent, myself and the attorneys I'm working with, 160 individual landowners consisting of over 5,000 acres, where we're contesting in this case against Chesapeake, saying that we do not believe that you're interpreting the contract language properly, that there are deductions being taken for such items as post-production costs and gathering, which should not be taken from our landowners' royalty checks. There is a proposed class action settlement in the case of Demchak versus Chesapeake, which is filed in federal court. Again, you need to get this information. Please, get this information and make your own decisions. We have intervened and objected, saying that we don't feel that settlement is appropriate. I believe there are 13 plaintiffs in the Demchak case, and again, we have 160 clients, and that number grows. And what happens is landowners contact us. You want to get more information, get it on your own. Get information. It's so darned important to get information, understand this issue, and make the decision for yourself. You don't have to just listen to me tell you. Make the decision for yourself. And what we do, so if you want to find out, does this whole situation apply to me? And I don't understand how anyone wouldn't want to find that out, because it's so important. Does this apply to me? You can contact me anytime, 570-307-0702. I give free, confidential, no obligation whatsoever evaluation of your oil and gas lease to tell you, does this whole situation even apply to you? You need to know this. What you do from there, you don't have to do anything. But you find out, does this involve me? What's going on here? Do I need to know something? And what do I need to know? And what I do is get back to you and say, hey, yes, this proposed class action settlement, in my opinion, does apply to you. Here's some information, some more, but please go out and get whatever information you'd like. If you'd like to join us and you want to be a client, we can give you more information about that, but there's no obligation to do that. What it is an opportunity to understand this is the issue in Pennsylvania, the issue across the state of Pennsylvania. You need to understand, how does this issue impact me, if at all? So if your lease, just quickly, if you're leased to Chesapeake in whole or in part, so if they own just a portion of your lease, and you have this term in your lease, this market enhancement clause or similar language, I can't say that enough, or similar language. I don't know. I haven't seen a lease yet in Pennsylvania where Chesapeake is not taking deductions. I haven't seen one yet where they're not taking deductions. So you need to find out, do you have this language that this Demchak proposed settlement would apply to you? You need to find it out. Again, what you do with that is your call. But you need to understand, am I a part of this class or group of people that's impacted? You need to find that out. We'll give you a free evaluation, let you know. Contact the office. We'll explain what to do. You send in your lease. If you're getting any checks, you can send in 1 month check. Again, we're not giving this information to anyone. We'll get back to you and say, hey, look, I think, my opinion, this applies to you, or my opinion, this doesn't apply to you, and here's some more information. Here's some areas where you can get some more information, and whatever you do, that's your call. But as I've said since August of 2010 on the radio, you need to get good quality information. You need to be informed and educated and make that decision for yourself. You need to understand this issue. You need to know, does it apply to me? And just leaving it with, a lot of people say, well, I'm not getting royalty checks yet, so this doesn't apply to me. Or, I'm not getting royalty checks, so I'm not sure how big of an issue this is to me. Well, that issue is, it's not necessarily the money, and it's going to be a lot of money in many, many cases, and in the big picture, it's going to be absolutely a lot of money, but we're talking about percentages, and what do I mean when I say that? Well, if it was $100 in a month, and that's a very low amount of deductions. We see them in thousands and sometimes tens of thousands of dollars a month. But say it was $100. We're not just talking about $100, well, okay, it's not a big deal, it's $100, what am I going to get? It's the percentage of that. So with the proposed settlement moving forward, instead of the landowner getting $100, they would get $27.50, and that would occur for the lifetime of the lease. So you need to get this information. Now understand, look, with every case, there's some potential. You always have the potential to win, and you always have the potential to fail. So you need to understand all of these things and make that decision for yourself. But you can't, in my opinion, you just can't sit on the sidelines and not be informed. I say this often. If you want to sit on the sidelines, sit on the sidelines. But be an informed person on the sidelines. Don't just sit there not understanding what's going on in front of you. Sit there on the sidelines and understand and make a conscious decision that this is where you want to be. Okay, we get back. I'm going to talk about pipelines. We'll take a break on the royalty segment. I am Attorney Doug Clark. This is All Things Marcellus. We'll be right back after this break. Good morning and welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Okay, want to switch gears here. I want to talk about pipelines. And if you're a regular listener, you know I talk about pipelines often. And pipelines still, of all the clients that I currently have active, I have more active pipeline clients than any other issue, well, aside from the royalty issue. But I have many, many active pipeline clients and clients all across the state. Do pipeline agreements in the western part of the state as well as the northeastern part of the state and in between. I've done probably several hundreds of pipeline agreements in the past, and have many going on right now at the present time with many different companies. In fact, I have reached agreements representing clients and against companies in the negotiation process. We've reached agreements, clients through the office, in over 40 different pipeline companies all across the state. And I say that because experience is so important to understand what terms companies offer, what terms different companies will agree to, what is the market in different areas. And pipelines and these pipeline right-of-way agreements they're very similar in a lot of ways to the oil and gas leasing. And what do I mean when I say that? Well, when gas leasing first started, what we had was, land guys coming out, making an offer, these landmen to landowners, telling the landowners, what they wanted to hear, or what they wanted to tell them, and not giving them all the information, all the different terms, explaining, maybe there was more compensation. Remembering the land guys work for the gas company, not the landowner. I always say, ask them to show you their business card. It's not going to say, Mr. Landman representing the landowner. It's going to say their name and who they're representing and what company. So you have to understand that they represent the company. So you, right off the bat, need to understand and appreciate what you're dealing with. What are your circumstances? So when the land guy comes out and we see with the pipelines, and what I say is in a lot of ways similar to the leasing, over the time since I started doing the pipeline agreements, I have seen the numbers and the offers per foot or per disturbed acre generally increase across the board. What companies were offering early on, most of them are offering more, in some cases much more than they were before. So we have a situation where the landowners who signed early are looking at neighbors and other people in the region who are getting more money per foot. And not only more money, but better terms, because the first people weren't as informed. So what do? We always need to learn from past experiences. What we do with regard to past experiences, we learn from our own bad experiences in the past, but we also learn from experiences that other people have had in the past. I preach to my two boys. I often say to them, I say, look, one great sign of being intelligent and making good decisions is to understand, yes, we're all going to make mistakes, and you're going to make mistakes. But when you see your friends or you see other people make mistakes, you can benefit from that observation. You don't necessarily need to make that mistake again. So when you see somebody else make a poor decision, or maybe it wasn't even a poor decision, that something occurred based upon their actions and it had a bad result, hey, let's go ahead and look at that from our perspective and say, hey, look, this person acted in this way and it produced a bad result. I should take a lesson from that and look to not act that way, or not, in our case, not jump into an agreement because I've seen that other people have done that and it's produced a bad result that I want to avoid. So it's not that we as an individual have to make a mistake and learn from it. We have the ability to learn from mistakes of other people and make sure that we don't repeat those errors or those mistakes. So a nice thing for me on behalf of the clients is, what we have is we see clients, and I see landowners who made mistakes in the past and they come to me for a new agreement or something different. So we're always learning. That data bank of education and knowledge is always growing, because we're always looking at, hey, where was a mistake made in what area and how can we do better? What can we do to change this? And that's what the companies do. That's what they do across the board. You take their right-of-way agreements, their lease agreements, understand these things have evolved over 100 years and sometimes more. And what do I mean? Well, when they enter into a lease and some term or a clause or an item or some language comes back to bite them or create a problem, what do? They change it. So when you're getting that first document, that didn't just get drafted the day before. That has evolved over many, many decades and sometimes a century. That's evolved. So every single thing in that document is designed to protect the company. I assure you of that. Everything in there is designed to protect the company, and those things that are in there that may be beneficial for you, those are the nuggets that they're going to use to try to sell you this agreement. They're selling you an agreement. So as the landowner, you have to understand, and I'll say it and I'll say it and I'll say it, you have to understand your leverage, your ability to say no, what you can do with this agreement, and you want to maximize this agreement. Now, many gas leases allow for a pipeline to go from a well that you're participating in. If you're a part of a unit and they want to run a pipeline away from that unit across your property, most gas leases, unless you have a complete non-activity, no surface disturbance, no surface use, whatever we want to call it, agreement, almost all agreements are going to allow the company to install a pipeline across your property if it's only transporting gas from wells which you are participating in that include your property. Almost all agreements allow that. Now, on the flip side, and this is so important, almost all, in the vast majority, I'll say, of agreements out there, of gas leases, do not, please pay attention, most agreements that are gas leases do not allow the pipeline or gas company to transport gas across your property through pipelines unless that gas is in part produced by your property. Let me say it a little better than that. What we have is you enter into a gas lease. Normally, that gas lease, in most cases, in almost all cases, but absolutely most cases, is going to allow the gas company to install a pipeline that will transport the gas from a unit which you're participating in. That makes a lot of sense. Doesn't make a lot of sense that the gas company would come in, drill wells, have a unit of production where gas is going to be drawn from, and not be able to get that gas out in pipelines from these wells to get it to the market to sell it. Makes all the sense in the world. And you as a landowner, hey, yeah, if I'm going to get royalties, I would like, I'm going to need pipelines to come from the well site to get off my property to go get that gas to market. Makes sense. Now remember, this was the deal from the beginning. This was the lease agreement. This was your deal. I am a person as a fundamental belief that says whatever your agreement was that you made, you stay to that agreement. You keep to your agreement. I think most people out there are. That's how I was raised, and that's how I am, and that's how I raise my children. You make an agreement, you stick to that agreement. Whenever these agreements were made, when this gas lease was made, that was your agreement. So as a landowner, when they come back to you and say, hey, we want to run a pipeline across your property, question number one, is that gas only going to be my gas or gas from a unit which I'm a part of? That is the first question. And then number two, does my lease permit you to run these pipelines through my gas lease? Just as your situation where we say you follow the agreement, which you should, the company, must also follow that agreement. So if the company doesn't have the rights to install this pipeline under the gas lease, they had the ability to approach you for a pipeline agreement or to get those pipelines before, but they didn't do that if that's the case here. So that's not your agreement. They're asking something new from you. They're asking something new from you. And if you don't have to agree to it and you don't want to agree to it, do not agree to it. But you need to understand what are the potential benefits and detriments, and is this worthwhile for me to do? Remember, I started off by saying leasing or pipelines now are a lot like the gas leasing used to be. And what do I mean by that is that there are a lot of people signing bad pipeline agreements, and a lot of people have signed bad pipeline agreements because they were misled, not given all the information, and don't understand the agreement that they're presented. Just as the gas guy, just as the landman came out in 2005, 6, 7, came out waving this agreement in front of you, this lease, and saying how this is going to be money, 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 and everyone sees dollar signs and can't get to your pen quick enough to sign the document. Okay? It's the same process. They come here with the pipeline agreements. They say, hey, we need to get pipelines to get the gas to market. We need pipelines. We need to get the gas to market so you can get big money royalties. Question 1, wait a second. Is this my gas? Do I have the ability to say no? Question 2, okay, you want to get me royalties. This is how I'm going to get royalties. This is getting gas to market. Here's a question, sir. How long after I sign this agreement does the pipeline company have to install these proposed pipelines? And you're going to find many times that answer is going to be 3, 4, 5 years, and sometimes much longer. Sometimes much longer. So when you're promised, and believe me, it's always an urgency. They come out, it's always an urgency. They don't want to leave your kitchen table without a signed document. And if they do leave without a signed document, they want to leave you with the impression that, boy, you better hurry up and get this thing signed because we want to get you royalties. Well, you're never going to be the only landowner in this pipeline from point A to point B. There's a lot of other people involved in this, and everyone's going to have their own different perspective. Some people are just going to run and sign. They're going to buy the story that they're being told. Other people are going to step back and say, you know what, let me look at this. Let me consult with somebody and decide if this is something I want to do. Some people are going to say, you know what, I don't want you on my property. Get rolling, get traveling, get the heck out of my kitchen. I don't ever want to see you. And then what are they going to do with that person? Well, if they don't have the ability to install that pipeline, they're going to have to go around that person. They're going to start knocking on neighbors' doors. So you have to understand these circumstances. I've had clients, people often say, well, how much do you get a foot or this or this or that? Well, if you have a straight pipeline that's going from a well that you're participating in, and it's solely going from that well pad across your property, you're not going to get a lot of money. Your negotiation leverage is not going to be great because ultimately the company can install the line under the lease agreement in almost all cases. So what does that mean? Well, what I do with those clients is we establish if that's the case. Then we say, okay, landowner, client, here's what we've done before. Let's go ahead. Let's maximize this pipeline agreement. Let's get in and get out. Let's make sure that this pipeline can only carry your gas. Let's make sure of that. Let's get you a nice, solid agreement for the highest compensation rate we can and get out of Dodge. We don't need to spin wheels and ask for all these crazy things that we can't get because we don't have this leverage. And we don't have to spin wheels and ask for more money, more money, more money. Well, we're not going to get that because ultimately we know the company can install this line anyway. So we want to get you the best possible agreement as efficiently as possible based upon doing this many, many times in the past. But there's a difference where, what if the company doesn't have the ability to install this line? What if they don't? Well, let's talk about that. Let's talk about your leverage, and let's talk about what your options are and how do you want to proceed, and do you want to push this? How important is this? Do you want a line? How much money is involved? And that's where it gets much more interesting, and you have a lot more leverage. But you got to remember, they're going to go knock on your neighbor's door. So the key to these is assessment of leverage, number one, and what you can do. And then obviously the terms and the items that are going to be involved in agreement. I'm way past my break. We'll get back. We're going to talk more pipelines. You're listening to All Things Marcellus. We'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Reminder, we are here every Sunday on all these stations from 8 to 9 a.m. to get you this valuable information you need about the natural gas and Marcellus Shale development and Utica Shale, the development of natural gas all across the state of Pennsylvania. Talked a little bit about the royalties today. I want to just give everyone that reminder. You need to understand, does this proposed class action settlement in Demchak, does our Burkett versus Chesapeake arbitration case, do these cases apply to you? Are you part of this class? You need to know this. And so I do free, confidential, no obligation whatsoever evaluation to get you that information just to let you know, do I think that Chesapeake or other companies are inappropriately taking deductions from your royalty checks? Get you that information and let you know. You can contact the office 570-307-0702. Again, it's 570-307-0702. And if you need representation in any area or anything, you can always call me as well. But, we'd like to make this not just one big giant commercial, but we want to get you information out there. So if you need representation, you need information, just, give us a call, 570-307-0702, and check out the websites, pagasleaseattorney.com. I taught some today, just recapping, we talked about the royalty issue. I talked about lease amendments and modifications. They are very important documents. You want to make sure you're getting assistance with those and that you understand these documents. I know, because I've seen it. People are making bad decisions and choices because they're just not informed. They don't have all the information. So please make sure you're getting this information. These are very important documents. This land, in most people's cases, is the biggest asset, the most valuable asset that you have, not just financially, but also emotionally. In many cases, this land has been passed down from generation to generation. So we want to make sure that you are taken care of, that you're maximizing any potential benefit. And whatever you're agreeing to, that you understand what you're agreeing to, and you understand what will be the future implications of these documents. Super, super important to understand these things. I also talked about the royalty, talked about quickly in the mediation, the importance of understanding your situation, your position. You need to know, and we'll be more than happy to give you a no obligation evaluation and let you know where we stand or you stand, and does this whole situation apply to you. Very, very important. Again, find out more, pagasleaseattorney.com. You can go look it up too. You can look up the Demchak case. These are public record documents. Get informed, get educated. I do not need to be your only resource. We want you to be informed. We want you to be educated. Not here to mislead anyone. We want to get people the information, get people truthful, credible, quality information that you make the decision with. Okay, in the last segment, I was talking a lot about pipelines. I can't overstate the importance of understanding this proposed pipeline agreement if you're given one, and making sure you're maximizing it. I want to explain this concept here in this last segment, and this is very, very important. The landman, who's he work for? The company, not us, okay? Not the land owner. He works for the company. So what we need to do is understand, when you're given this proposed gas lease, you want to look and say, hey, wait a second, this is an option agreement in most cases, which means the company has years to decide whether they're even going to do this or not. So you need to understand that. But here's what's happening, and this is something very, very important, and it gets a bit complicated. It's pretty easy to understand, but it's complicated as well, as most things are. Okay, so landman comes to the door and says, hey, we want to put a pipeline across your property. This is going to get you money. This is how you're going to get the royalties. We're going to start producing, and the landowner gets really excited. Hey, I entered into a gas lease a long time ago, all these promises of royalties, and I'm not getting them. So what does the landman say? Well, hey, you sign this magical document, and here you go. You're going to start getting royalties. We want to get this done. Remember, you're going to look and see, well, how quickly does this have to happen? But more importantly than even that, you need to understand, do they have the right to install this line or place these pipelines under your gas lease? Now, a lot of times, what you're going to find, little trick, big trick, so pay attention, please. What you're going to find is the landman was going to say, oh, well, if you resist this, or you're starting to ask a lot of questions, well, we can do this under your oil and gas lease. Your oil and gas lease gives us pipeline rights. Well, That may be true. In most cases, it is true. However, a big, giant however, what about this specific case? And what exactly does my gas lease give you? What rights do I give you in my gas lease, pipeline company? And yes, although my gas lease may give you pipeline rights, do they only give you pipeline rights to transport gas that is produced in part from my property, not neighbors down the road, not units that I'm not a part of? And that's very, very often the case. Very often the case. So what happens is the landmen who do this for a living understand. They go to the landowner and they say, hey, yeah, look, we can install pipelines under your lease. Well, yeah, maybe you can. But can you install these pipelines under your lease? Also, or under the gas company's lease. Also, phase 2, the second step to that. Well, maybe you can even install these pipelines under my lease. But can you transport gas from other properties across my property or through these pipelines? And usually that answer is no. So what does this mean? Well, in some cases, we get in this battle where the company wants to strong-arm the landowner and say, hey, look, we can do this. We'll install these under the lease. If we do that, you're going to get peanuts. We'll just give you a few dollars, and you're missing out on a lot of money here. Or you're missing out even on $10,000. We're going to give you $1,000 or $500. Well, here's what you need to know. This is a little secret that nobody wants to tell you. If you're in this particular circumstance, well, maybe this is a situation where you say, okay, company, you know what? You threatened me to do this under my lease. You're getting very tough and bullying me and saying we're going to do this under your lease. And we're going to give you much less money, and you're a very foolish person for not doing this, not signing this agreement. Well, if you're in that circumstances, and the key is you have to understand if these are your circumstances, and you're probably going to need help to do this, but you can do it in some cases on your own, but I don't recommend it. You have to understand your circumstances. So you say, you know what? Okay, fine. Here's what we'll do. You can install this line under my lease, but you know what you can't do, company? You can't transport third-party or foreign gas from other properties across my property. So go ahead, maybe give me a very small amount of compensation today. In the long run, it's not going to be that big of a deal to me because I'm going to hopefully be getting royalties, and this $10,000 or $20,000 difference today, yeah, that's a lot of money. But in the bigger giant picture, I don't want to have this, so I'm going to let you go ahead and agree to do it under my gas lease. But I'll tell you this, don't run any other gas through these pipelines, because once my lease terminates, once my oil and gas lease terminates, you no longer have the right to have these pipelines in my ground and transport gas. That's a very important situation that you need to understand. Now, I said before, every circumstance is different. Every circumstance is different. So this is an example of hidden leverage that a landowner may have, and we've had in many cases and used to the great benefit of a client in many cases. You look and you say, okay, yeah, company, you want to strong arm me and say, hey, we can do this anyway, we can do this anyway. Well, remember that if you do it that way, the only gas you can run is from my well sites that I'm participating in. That's all you can do. And once those sites are done, once they're dry, once my property is no longer involved in gas production, you can't use those pipelines. So companies see this bigger picture. They recognize that your lease may terminate 20, 30, 40, 50 years, but they want pipelines for the next century. 100, 150 years, who knows how long. They don't want to use those lease rights if they don't have to, because in most cases, remember this is most cases, they want the ability to expand in the future. And that's where you may have some leverage that, yes, company, maybe you can do this under my lease, but You know and I know that you don't want to do it that way. You want me to sign a new agreement because you want to use these pipelines to transport not just my gas, but many other people's gas as well. And that being the case, I now have some more leverage. Maybe that means making it a smaller easement. Maybe that means more compensation. Maybe that means if there's going to be additional lines, that I get paid for each additional line. There are many things that a landowner can do. And that's why I say, circling back around, just like the leases, you need to understand there's a lot of hidden things that you can do in most cases to help yourself. And if you have experienced person helping you, experienced attorney helping you, they're going to maximize those. So again, whether it's me or somebody else, get this assistance. I'm going to be talking more about pipelines. I've done agreements with over 40 different companies. We've seen this happen. So you want to make sure that you understand your situation, your exact circumstance, and know what you can do. I am Attorney Doug Clark. This is All Things Marcellus. We're at the end. Have a great week, everyone.